MOOC on Democratic Awareness with Legal Literacy. Welcome to the class. Today's topic is offences affecting human body, murder and culpable homicide not amounting to murder. Crime consists of specified physical act coupled with mental element of the person committing the physical act. This physical act is called actus reus, and the mental element of the person committing the physical act is called mens rea. When actus reus is combined with mens rea, crime is made out. Crimes are identified as offences by enacting the penal law. I am giving an example how mens rea plays pivotal role in fixing the criminal liability of an individual. Suppose a person is driving a motor vehicle and thereby runs over a person and kills him. This physical act may give rise to three different offences. The person who is driving the motor vehicle, if he had the intention to cause death, then it is murder. If the person driving the motor vehicle had knowledge that bodily injury may be caused and that bodily injury may likely to cause death, then it is culpable homicide not amounting to murder. If the person driving the motor vehicle has taken all precaution and he has no intention to cause death, no knowledge that bodily injury will be caused and thereby death will be the natural consequences, even then death is caused due to rash and negligent act, then also it is an offence. Offence is causing death by negligent act, which is of lesser category of offence. Now, if the person who is driving the motor vehicle has run over the person and kills the person due to failure of the brake, then criminal liability cannot be fixed on the driver of the vehicle. Remedy is by way of compensation. So, mens rea plays important role in every offence. Now, criminal liability cannot be fixed on a child below 7 years of age. If a child is above 7 years of age and below 12 years of age, and if he has sufficient maturity of understanding and he is aware of consequence of the act of committing the offence, then criminal liability can be fixed on the child. A person who is innocent, an innocent person may commit an offence, but he is not aware of the consequence of the act. So, criminal liability cannot be fixed on a person during the period of insanity. If a person is intoxicated by consuming drug or by taking alcohol, then he is not aware of the consequences of the act. He will not be criminally liable provided intoxication is not caused voluntarily. If the intoxication is caused without his knowledge, against his will, without his consent, then criminal liability cannot be fixed for causing any offence. Apart from that, under the law, every human being has a right to protect his own body and his own property, as well as body and property of a relative, neighbor and friend. So, when a person is using force for protection of his body, property and protection of body, property of friend or relative or neighbor, then that is called right of private defense. If anyone uses force and thereby causes death of a person, and that is in discharge of right of private defense, then criminal liability cannot be fixed. So mens rea plays very important role in identifying the offence and in fixing the criminal liability on an individual. In body offences, all body offences are defined under chapter 16 of Indian Penal Code. There are various types of body offences, starting from simple hurt, grievous hurt, rape, outraging of modesty, abduction, kidnapping. So various types of body offences are available. In every definition of body offence, mens rea is defined along with the definition of the offence by using the term intention, intentionally, knowingly, dishonestly, voluntarily. These terms are used to identify mens rea in the offence. Now, we will discuss mainly murder, culpable homicide not amounting to murder, and causing of death by negligent act. There are three different kinds of mens rea. If those mens rea takes place, then it will be culpable homicide. What are those mens rea? When a person is killed with intention of causing death, that will be culpable homicide. If a person is killed with intention of causing such bodily injury as is likely to cause death, then that is culpable homicide. If a person is killed with the knowledge that the act is likely to cause death under normal circumstances, then that is also culpable homicide. Now, culpable homicide may amount to murder, culpable homicide may not amount to murder. When the culpable homicide will amount to murder, some special mens rea must be identified. So, there are four types of special mens rea from which murder can be identified. What are those special mens rea? First, when a person is killed with intention of causing death. Second, when a person is killed by causing such bodily injury as the offender knows to be likely to cause death. Third, when a person is killed with intention of causing such bodily injury as will cause death under normal circumstances. And lastly, when a person is killed by doing an act which is so eminently dangerous as will definitely cause death. For the last mens rea, I am giving an example. Suppose a plaster cast is given on the face and head of a person, keeping the nostrils open. Now, if the nostrils are closed with cotton soaked with chloroform, then this act is so eminently dangerous that death will be definitely the natural consequence. So, that is murder. Now, culpable homicide may not amount to murder. When culpable homicide will not amount to murder? When death is caused under grave and sudden provocation, and the person who is committing the offence is deprived of power of self-control. I am giving an example. Suppose a person has suddenly seen his wife in compromising position with the neighbor. He suspected previously that there is illicit relationship between his wife and the neighbor. When the person will see this incident, so that will provoke him to commit a crime. So, by seeing this, by this sudden provocation, if the person takes an iron rod and gives a blow of that iron rod on the head of the neighbor, and the neighbor dies ultimately, then this is an act of culpable homicide not amounting to murder. When death is caused exceeding the power in exercise of right of private defense, then also it amounts to culpable homicide. I have already pointed out that a person can use force in exercise of right of private defense. Now, if the power which is given under the law, if that power exceeds, then it will be culpable homicide not amounting to murder. When death is caused by a public servant or a person who is aiding or abetting the public servant, then if he exceeds the power which is given under the law, then also it amounts to culpable homicide not amounting to murder. When suppose there is a fight between two persons or hot exchange of words between two persons, suddenly one person takes up one weapon which was falling on the ground and gives a blow by that weapon, and the other person dies. Then it happens on the spur of the moment. This is culpable homicide not amounting to murder. If a person who is adult, above 18 years of age, and if he takes the risk of his own life and thereby death is caused, then also it is culpable homicide not amounting to murder. That there are different punishments prescribed under the law for murder, for culpable homicide not amounting to murder, and for causing death by negligent act, or generally it happens in case of rash and negligent driving. So, what is the punishment for murder? Punishment for murder is either death sentence or life imprisonment. Life imprisonment is the rule, death sentence is an exception. Death sentence can be imposed when it is a rarest of the rare case. The court will assess the aggravating circumstances and mitigating circumstances appearing in favor of or against the person, and will also apply the crime test, that is the circumstances under which the offence took place. And then if the court is of opinion that the accused is beyond reformation, then only death sentence can be imposed. Otherwise, life imprisonment will be imposed for committing the offence of murder. Now, life imprisonment, what does it mean? Does it mean the normal life of a person, entire life till death? No. Generally, life imprisonment means if the person who suffers life imprisonment, if he performs good behavior for his conduct and good behavior inside the correctional home, he is entitled to get remission of the sentence under the jail code and also by the state under the provisions of Code of Criminal Procedure. So, when remission is granted to a life convict, then the entire period of life imprisonment is considered as 20 years. For good conduct, this 20 years is reduced to either 14 years or 12 years, depending on the good conduct and good behavior and depending on the power of remission exercised by the state or the jail authority. Now, there are some cases of murder where death sentence is not warranted, whereas life imprisonment with power of remission is inadequate sentence. In those circumstances, the Supreme Court has evolved another category of sentence, which is life imprisonment till the end of natural life of the convict. So, when this sentence is imposed, this sentence of life imprisonment is imposed, then there will be no remission and the person will have natural death in the correctional home. Now, punishment for culpable homicide. There are two types of culpable homicide not amounting to murder. One is aggravated form of culpable homicide not amounting to murder. Another is lesser degree of culpable homicide not amounting to murder. For the higher degree of culpable homicide not amounting to murder, maximum punishment is life imprisonment. For the lesser degree of culpable homicide not amounting to murder, maximum punishment is 10 years imprisonment. Now, this punishment, the minimum sentence is not prescribed under the law for culpable homicide not amounting to murder. If minimum sentence is prescribed by the legislature in the penal law, then the court has no discretion to impose a sentence which is less than the minimum. Since minimum sentence is not prescribed for offence of culpable homicide not amounting to murder, the judge has huge discretion to impose any sentence which will be less than 10 years imprisonment in case of lesser offence of culpable homicide and less than life imprisonment in case of higher degree of culpable homicide not amounting to murder. Now, I have already pointed out there is another form of death, another form of offence, that is causing death by negligent act. Here also punishment is maximum 2 years of imprisonment and minimum sentence is not prescribed. So, here also the judge has huge discretion to impose minimum sentence. So, that can be 2 months of imprisonment, that can be 6 months of imprisonment, it can be 1 year of imprisonment. So, depending on the nature of the offence, I mean the circumstances under which the offence was committed and the background of the convict, the quantum of sentence will be decided by the judge. I would like to discuss a few important cases decided by the Supreme Court. First one is Keshu Mahindra versus State of MP. This is popularly known as Bhopal gas tragedy. In 1984, in the month of December, there was leakage of methane gas from the factory of Union Carbide in Bhopal. Many people, more than 3,000 people died and about 18,000 people were permanently disabilitated. So, and many cattle also died in that incident. The trial court framed charge against the persons who were in charge of the factory at the time of leakage of the gas and also against the office bearers of the company of Union Carbide. But that was challenged ultimately, initially before the High Court and ultimately before the Supreme Court. The Supreme Court reduced the gravity of the charge. According to the Supreme Court, the persons who were in charge of the factory at the time of leakage of the gas and the office bearers of the company had no knowledge that death may be caused by leakage of gas. According to the Supreme Court, it is a case of negligent act on the part of the persons who were in charge of the factory and also on the part of the persons who were in the helms of the affairs of the company. So, that charge was reduced to a charge of causing death by negligent act. Another case is Alistair Anthony Pereira. This is a case where a person was driving a car in drunken condition at late night. And the car ultimately, the person who was driving the car lost control of the steering and the car came to the footpath and ran over 7 persons who were sleeping in the footpath in the night. So, 7 persons died instantly. So, ultimately when this case went to the Supreme Court has laid down that if a person is driving a vehicle in drunken condition and thereby causes death of a person, then it will be the criminal liability of the person will be culpable homicide not amounting to murder, which will be punishable with imprisonment up to 10 years. So that is the law laid down by the Supreme Court in this case. Another case is Jacob Matthew versus State of Punjab. This is a case where a doctor was prosecuted for causing death of a patient by giving negligent treatment. This criminal proceeding was challenged by the doctor initially before the High Court and ultimately before the Supreme Court. The Supreme Court held that if a doctor causes death of a patient by negligent treatment, then generally it is not so gross negligence that doctor will be held criminally liable. Doctor is bound to give compensation, but criminal liability cannot be fixed. And if at all criminal liability is to be fixed, then expert opinion must be obtained from another doctor, preferably from a government hospital, and the expert must have the same knowledge and experience as that of the accused person who is being prosecuted. Without that expert opinion, the court or the police should not proceed with the criminal proceeding against the doctor. Now here I would like to clarify that suppose a homeopath doctor treating a child of 7 years of age who has been suffering from high fever and pain in the abdomen. If the homeopath doctor has given one allopathy injection and thereby the patient collapsed and died, then the homeopath doctor will be held liable criminally for causing death of the patient by negligent act. Why? Because the homeopath doctor had no knowledge and skill of administering allopathic medicine. In spite of that, he administered allopathic medicine and thereby caused death of the patient. So this is gross negligence, for which doctor will be criminally liable. Now another case is Swami Shraddhananda versus State of Karnataka. I have already pointed out that the Supreme Court has evolved a third punishment which is less than death sentence and more than normal life imprisonment with power of remission. So in this case, the Supreme Court has evolved that particular punishment by which life imprisonment will continue till the end of natural life of the convict. Now another case is Sangeet versus State of Haryana. In this case, the Supreme Court has laid down that when remission will be granted to a life convict, either by the state or by the jail authority, then the jail authority or the state government must obtain consent of the or the views of the presiding officer of the court which imposed life imprisonment. Now another case is Siddharth Vasist alias Manu Sharma versus State of Delhi. This is popularly known as Jessica Lal murder case. In this case, Jessica Lal was a bartender and when the bar was almost closed and the serving of liquor was also closed, Manu Sharma entered into the bar and demanded liquor from Jessica Lal along with his friends. Jessica Lal refused to serve liquor on the ground that the bar is closed, so liquor cannot be served. Manu Sharma became furious. Initially, he fired in the air and ultimately he shot Jessica Lal dead. And the bar was at that time crowded. There were many eyewitnesses. But Manu Sharma was the son of a minister. His father was a leader of ruling political party. So he had some influence, and thereby all the eyewitnesses who were present in the bar, all of them became hostile. They said they cannot identify the accused person, but the owner of the bar, a lady, she ultimately identified the accused person, but in this case, the bullets which were seized from the room and the bullets which were seized from the body of Jessica Lal during postmortem examination were sent to the ballistic expert along with the revolver which was seized from Manu Sharma, and the ballistic expert gave opinion that the bullets which were found in the room might have been fired from the revolver of Manu Sharma, but the bullet which was found in the body of Jessica Lal, that was not fired from the revolver of Manu Sharma. So, the theory of presence of another person was made out from the defense, and the case ended in acquittal. There was huge uproar in the media, and there was protest throughout the country. And when the appeal was preferred before the High Court of Delhi, the High Court of Delhi evaluated the entire evidence and discarded the evidence of ballistic expert and relied on the evidence of eyewitness, which was trustworthy and creditworthy, and the case ended in conviction, and Manu Sharma was convicted and sentenced to imprisonment for life, and thus that decision of the High Court was upheld by the Supreme Court. The last case I would like to point out is this is Sushil Sharma versus State of Delhi. This is popularly known as Tandoor murder case. Sushil Sharma was the leader of Delhi Youth Congress, and Naina Sahni, the victim, was the leader of women wing of Youth Congress of Delhi. They had love affairs and ultimately they got married, and Naina Sahni was living in the flat of Sushil Sharma, but Sushil Sharma suspected the illicit relationship of Naina Sahni with one of her friend. So, due to this suspicion, one day there was hot exchange of words, and Naina Sahni was shot dead by the licensed revolver of Sushil Sharma. And the dead body was brought to the barbecue. There was a barbecue which was started by Sushil Sharma near Ashoka Hotel in Delhi. In that barbecue, dead body was brought in the night and dead body was burnt. When the smell of burning human body was spread, the police on patrol duty came to the barbecue, knocked the door, came inside and found the dead body of one lady in the barbecue. Manager was arrested and the dead body was sent for medical examination in the Ram Manohar Lohia hospital, and no bullet could be detected from the dead body. When postmortem examination of the dead body was done, even at that time, the bullet in the dead body could not be detected because X-ray machine of the hospital was out of order. So, a second postmortem was conducted in another hospital by a team of 3 doctors, and with the help of X-ray machine, they found 3 bullets in the dead body, on the back of the neck of the dead body. Dead body was identified as the dead body of Naina Sahni from the DNA test of her parents, and ballistic expert opinion was that the bullet which were found inside the dead body were fired from the licensed revolver of Sushil Sharma. So, ultimately the case ended in conviction. In spite of discrepancy in the expert evidence, the court explained and ultimately said that since the X-ray machine was not available and since the half-burned body was examined, it was quite natural that the doctor could not detect the bullet injury on the dead body. So, ultimately the second postmortem report was relied upon and the case ended in conviction, and Sushil Sharma was convicted and sentenced to imprisonment for life. Thank you.